The word around town is that you're back in town, and I try not to think about it. I try, but it's been so long, and I thought I moved on, but now I really doubt it. I do. I wonder why you even come. It's almost like you're having fun with me. But oh, if I set my eyes on you, it's unavoidable. I'll come undone. Oh, I thought you were gone for good. So why you have to pull me back? Maybe you say you won't be coming back. Oh, damn you. This is really bad.
The following, please be seated on the reserved special table. Of course, we already have seated the Chief Justice of Nigeria and Chairman of the occasion, my Lord, the Honorable Justice Walter Nkanu Onogen, GCON, CJN. If not already seated, I would like to ask that the former Attorney General and Minister of Justice in the person of His Excellency, Prince Bola Ajibola, CFR, KBE, SAN, to please also be seated on the special table. If not already seated, I'll also like to ask that a former Attorney General and Minister for Justice, His Excellency, Chief Bayo Ojo, CFR, SAN, please also be seated on the special table. We will, of course, also call that the first female senior advocate of Nigeria, Chief Folake Sholanke, CON, SAN, please also be seated. We recognize your presence. I would like to ask that we have Chief Felix Fagbongbe, who is the BOSAN Treasurer, Chief Felix Fagbongbe SAN, who is the BOSAN Treasurer, to please also be seated. Thank you very much. Now, at this point, for the opening remarks, I would like to call on Professor Fabian Ajogu, who is the Chairman of Continuing Legal Education Subcommittee of BOSAN. And ladies and gentlemen, he is the principal of the law firm of Kenna Partners with offices in Lagos, Abuja, and Enugu. And he's definitely a distinguished member of the inner bar. Can we get a round of applause as he makes his way up? Thank you very much.
Thank you very much. My Lord, the Honorable Chief Justice of Nigeria, Honorable Justice Walter Onogen, GCON, my Lord, the Justices of the Supreme Court here present, Honorable Justice Galije, JSC, and Honorable Justice Ejembi Eko, JSC, my Lord, Justices of the Court of Appeal here present, distinguished learned senior advocates of Nigeria, ladies and gentlemen, may I start on a note of sincere apologies for the mix-up in timing. Our chairman for today's occasion has arrived on time 3 minutes ahead of the time written on his letter of invitation, and I do take responsibility for this. and sorry for having kept the rest of us waiting. It is my pleasure, and sincerely so, to offer you a warm welcome to the Maiden annual lecture of the Body of Senior Advocates of Nigeria. It is something that we take great pride in doing. But before I go any further, I would like to mention that one of our panelists who was scheduled to be here today and had gone through great pains to arrive at this occasion had a little incident yesterday. My Lord, the Honorable Justice Amina Oge, Justice of the Supreme Court of Nigeria, and we thank God that that incident has been contained. And so she's not able to be here with us on account of the minor injuries that she sustained. So we do pray that she gets well soon, and we thank God for his mercies and grace that all was contained. The Continuing Legal Education Committee of the Body of Senior Advocates was given the mandate to pull together a lecture series that will bring together senior advocates of Nigeria, members of the bench at the highest level, and members of the public to look at issues of professionalism, leadership at the bar, ethics, amongst other things, administration of justice, and nation building. So it was not a difficult thing to come up with the theme of today's lecture, which is the evolving role of senior advocates in the administration of justice. It is a fact that all senior advocates had to take an oath that stated clearly that they will uphold the Constitution and assist the courts in doing justice. In recent times, there have been calls and questions on whether we are living out this mandate or this injunction that we have put on ourselves. It is no doubt that we've had incidents which some could call as negative, but we also take the view that the gospel was propagated by 11, even though 1/12 of the disciples seemingly were corrupt. And it would therefore be wrong to paint the rest with the same brush as the 8.25%. And that is really what this is about. We want to sit and have discussions about our role as senior advocates of Nigeria and our contributions towards the administration of justice. We also want to hear perspectives from the other side and how we can assist, and hence the choice of the panel. We will be hearing from a very distinguished learned senior advocate, one of us. We're proud of him. He will be bringing us perspectives from the other side, from England, where we have taken most of our traditions and culture and practice of the law. We'll be listening to Professor Odita, Queen's Counsel and Senior Advocate of Nigeria, to bring us the academic perspectives, the practice of law from the other side in the United Kingdom, and his experiences locally. And hopefully we should then be able to refine these experiences to make us better in what we do. We would also be listening to the Chief Justice of Nigeria to hear some of the unique things that he's setting out to do in the reform of the judiciary and placing it at better heights. And that should give us insights into how we can then support that agenda and assist the courts better than we have. We have put together, and they have graciously accepted, a very rich panel of discussants. We will be listening to our very first female senior advocate of Nigeria, Chief Folake Solanke, SAN, and whom we're very proud of, who depicts one of the things that would be the hallmark of senior advocates: leadership and excellence. Excellence in the practice of law, excellence in finesse and courage, excellence in the way that she has walked her life. By the way, I should mention that Chief Solanke was teaching mathematics in England in 1955. And that should tell you about the excellence that we're talking about. Please do give her a round of applause. We would also then be listening to Chief Bayo Ojo, who has sat on that hot seat of being the Attorney General of the Federation and Minister of Justice, to hear his perspectives. We will be listening from the fountain of wisdom. The Honorable Justice Emmanuel Ayola brings so much wisdom to the table of good ways of doing things. And we will be hearing the perspectives from our MBA president, Mr. A.B. Mahmood, who's going to be represented by Chief Anthony Digbe, I'm told. Justice Amina Oge this morning asked me to convey her best wishes to this program and said she would make it up to us in subsequent programs. Even lying in the hospital bed, she still wishes us very well and is very positive about this. On behalf of the committee that I serve, I would like to welcome you to this program, but not without thanking the leadership of the body of senior advocates of Nigeria. It is a tradition that the oldest remains the leader, but then we have some functional leaders, and I must mention Chief Felix Fagboungwe, who has largely put this together, sitting at the back and making sure that this has come through. There will be the time for note of thanks and appreciation, and we will then convey our apologies very well. My committee members are here, and not all of them are here now, but they work in the ways that we want lawyers to begin to work, looking at efficiency. We have done a lot of conference call, a lot of work. Mr. Lumide Shofora, SAN, Mr. Nodeko, SAN is here, so we'll give them a round of applause. One of us graciously, and that is consistent with the way that the body wants to function going forward, to be self-sustaining. Chief Adeomi Ogunsanya, SAN, wrote in part the check for this event. I have told you for two reasons: to applaud him and to write me the balance of the check. Ladies and gentlemen, I offer the Chief Justice of Nigeria a warm welcome and reaffirm that my Lord keeps to his time. 10:57 he arrived, and I apologize for the mix-up. Please enjoy the lecture. Thank you very much.
Once again, the Chief Justice of Nigeria and Chairman of the occasion, my Lord, the Honorable Justice Walter Nkanu Onogen, GCON, CJN, my Lord, Justices of the Supreme Court here present, former Attorneys General and Ministers of Justice, my Lords Justices of the Court of Appeal and Chief Judges of States, learned senior advocates of Nigeria. At this point, I would like to call on an important person who will make an even more important introduction. Can you please warmly welcome Mr. Olumide Shofowora San, FCIR.
My Lord, the Chief Justice of Nigeria, permit me to stand on existing protocols. The MC has been doing a wonderful piece of work. I don't know why there has to be a special introduction for our Chief Justice of Nigeria. But since he has deemed it proper for me to do it, Chief Justice of Nigeria, Honorable Mr. Justice Walter Onogen, Grand Commander of the Order of the Niger, has been able to steer the administration of justice in this country in a way that is quite positive. And that is why he has been chosen to chair this occasion, considering that the title of the lecture is very, very apposite. It gives me the greatest pleasure to invite the Honorable Mr. Justice Walter Nkano Onogen to present his address. Round of applause, please.
Thank you very much indeed, and good morning. Please be seated, please. My Lord, Justices of the Supreme Court, serving and retired. My Lord, Lords Justices of the Court of Appeal. My Lord and former Attorney General of the Federation, Prince Ajibola, former Attorneys General, learned senior advocates of Nigeria, please at this stage permit me to stand on existing protocol. I have to apologize for the mix-up, not caused by me anyway. It's not in my character to be at any event late. So the circumstances have been explained to you. It's good, at least we are all here. So, I'm delighted to be in your midst this morning and to deliver this address at the Maiden Annual Lecture of the Body of Senior Advocates of Nigeria on the topic, how members of the inner bar can support the dispensation of justice and justice sector reforms, unquote. This annual lecture is unique because it is the first of its kind to be organized by the Body of Senior Advocates of Nigeria. This platform affords the participants the opportunity to brainstorm on matters of shared interest, exchange ideas and experiences, with a view to providing practical solutions and repositioning the legal profession for optimal performance. Distinguished participants, the theme of this maiden annual lecture, Practicing in a Regulated Profession, Challenges of Contemporary Law Practice, is undoubtedly pertinent and instructive. The legal profession as a regulated profession serves as the bearer of the justice system, as it is directly engaged in the administration of justice. As in the case of the medical practitioner, who is indispensable to the health needs of persons, the legal practitioner, through ethical representation of clients, plays an important role in the social lives of persons, which further transcends to the public's confidence in the justice sector. It therefore becomes imperative for us to ensure strict observance to ethical standards, integrity and the rule of law, which are the underlying principles of justice and the bedrock of democracy. The importance of the topic, how members of the inner bar can support the dispensation of justice and justice sector reforms, cannot be overstated. This is because of the very significant role you play in the dispensation of justice. You are accorded the enviable position of being the defenders of the judiciary and the bridge between the subjugated and the courts. Therefore, the society looks up to you to shun corruption and corrupt practices, conduct cases fairly, to act in accordance with the law and without fear or favor, to speedily dispense justice, but most importantly, to provide honest and disinterested advice to clients. It is only when these factors are adhered to that democracy, justice, rule of law, and order will thrive in our society. The reform of the justice sector is indispensable to the rule of law, as it is through the instrumentality of reform that the yearnings of the public can be met. Thus, measures required to strengthen the justice sector must be put in place. The success of judicial reforms depends not only on how we collectively identify and deliberate on fundamental issues affecting the justice sector, but on how we can ensure the pragmatic implementation of such reforms to the letter. It is imperative to mention that the actions of some members of the inner bar have recently been called into question. Let us remind ourselves that integrity is crucial to the judiciary, and the reputation her most important asset. The public have confidence not only in the courts, but in the members of the bar, who are the bridge between the courts and the public. Therefore, it is of necessity to come together to address the challenges you encounter and to incorporate your contributions towards the justice sector reforms, thereby expediting speedy dispensation of justice. Permit me here to state that we are not unmindful of the numerous challenges you face. However, the judiciary still looks up to you because of the position of trust you occupy. You must face up to your responsibilities, which carry attributes such as prosperity, propriety, integrity, honesty, impartiality, diligence, and objectivity. We must strive hard to exhibit and promote high standards of these conducts at all times, and to discharge our duties with competence and decorum, both in court and in our private lives. I urge you all to shun corruption and avoid all forms of misconduct, because if one is not qualified to wear silk as a judicial officer, he remains unqualified to wear same as a senior advocate of Nigeria. We must therefore realize that whatever reforms to be embarked upon must start from our mindset, attitude, etc., without which the effort remains an exercise in futility. I have no doubt, that this gathering will address the challenges you encounter in your profession, and will profess suggestions towards the speedy dispensation of justice and justice sector reforms. Thank you all for your patience and attention. May God bless us all. Amen and amen.
As well as Professor Adekunle Adedeji San. Another round of applause. I will now read. Well, I've been told that I shouldn't say too much about them, but if you want to learn a bit more, kindly look through the pamphlet in your hands and you will learn a bit more. So can we get another round of applause as they make their ways to the seats and indeed to the podium. Thank you very much.
My Lord, the Chief Justice of Nigeria and Chairman of this event, my Lords Justices of the Supreme Court here present, permit me to adopt the protocols already established. We have been informed, and I think we should have let you know this earlier, that the special guest of honor will not be joining us on account of an urgent matter of state interest, and he sends his apologies. The special guest of honor, Professor Yemi Oshibajo, GCON, is also a respected member of this body and the Vice President of the Federal Republic of Nigeria. He sends his sincere apologies and wishes this gathering well. Be that as it may, we are set for the event of the morning, and it is my special pleasure to call on our distinguished panelists. In the order that you have their names outlined in the program, may I respectfully ask my Lord, Honorable Justice Emmanuel Ayola, CON, Fellow of NILS, former Justice of the Supreme Court, who has aptly been described as a repository of wisdom here. He has many adjectives, but I simply prefer to call him as a mentor and a role model, one who has been quite instrumental not only to the administration of justice in Nigeria, but in countries far beyond the shores of Nigeria. Justice Ayola is someone who plays a key role in the evaluation and the growth and the shaping of the tasks and functions of judicial officers. And he plays this role well, coming with vast experience in judicial administration. He was formerly a president of the Court of Appeal in Seychelles. He was formerly chairman of the ICPC, and of course, he continues to lend his wealth of experience to the growth of administration of justice. Can we encourage Justice Ayola with a round of applause? We were looking forward to the presence of my Lord Justice Amina Ogi. We wish her a speedy recovery, and we pray indeed that God would avert incidents like this in the lives of all of us. Our next personality, as outlined in the program, is one who probably started out life as a female calculus, someone who not only prepared herself for life as a teacher of mathematics, but also Latin. Chief Mrs. Folake Sholanke has blazed the trail in the law in many areas. a proud daughter of a revered pharmacist, one who, at the height of her career, was acknowledged not just as a trailblazer in terms of her gender, but also in terms of the contributions that she made in the profession. The first commissioner to be appointed in Western Nigeria, the first chairperson of the Western Nigeria Television and Broadcasting Company, the recipient of the International Bar Association Outstanding Women's Lawyers Award, and the recipient of a Lifetime Achievement Award as late as 2015, and a proud fellow of the Nigerian Institute of Advanced Legal Studies. May we welcome Chief Olanke Sholanke, Senior Advocate of Nigeria. On. Our third panelist so it's when you anchor events like this that you notice that your glasses needs to be changed. I need to be sure that I don't miss out anyone. So our third panelist, we have Chief Bayo Ojo, Senior Advocate of Nigeria, Commander of the Federal Republic, called to the bar 1978. Chief Bayo Ojo has over 35 years experience in mediation and arbitration matters. He very recently was a member of the International Law Commission, and he is still a member of the Board of Trustees of the Chartered Institute of Arbitration. He remains an accredited tutor of the Chartered Institute of Arbitration, and we await with eagerness his book on arbitration and ADR practice in Nigeria. Can we encourage Chief Bayo Ojo, Senior Advocate of Nigeria, as he makes his way to the podium? Well, when I said we eagerly await his book, that's, you can be sure, will make Fabian very happy, because I'm sure he's going to slam an advertisement bill on Chief Bayo Ojo. But I know that we really cannot wait to have that book on the stand. And to Chief Bayo Ojo, I say that you can take that to the bank. The fourth panelist is the president of the bar, of the Nigerian Bar Association, Mr. A.B. Mahmood, Senior Advocate of Nigeria, who, as we have been told, is ably represented by one of our own, Mr. Tony Idigbe. But let me tell you a little bit about Mr. A.B. Mahmood. And although we'll be saying Mr. Idigbe, I have no doubt that he has been properly briefed by Mr. Mahmood. Mr. Mahmood was formerly Attorney General of Kano State and a founding partner of Diko and Mahmood Associates. He is currently president of the Nigerian Bar Association And we want to welcome his representative, Mr. Tony Idigbe, to the podium. May I call on my colleague to take the intro of our guest speaker. Thank you very much.
Thank you, Professor Adedeji. My Lord, the Chief Justice of Nigeria, permit me to stand on existing protocols again. Our guest speaker this morning is Professor Fidelis Odita, Queen's Counsel, Senior Advocate of Nigeria. Professor Odita was a partner at Fidelis Odita & Co., commercial law firm in Nigeria. It provides full legal services to local and international businesses with offices in Lagos and Abuja. He obtained his Bachelor of Laws degree with the first class from the best university where you can study law in Nigeria, that's the University of Lagos. And won 12 of the 13 available prizes, and thereafter proceeded to the Nigerian Law School where he graduated with another first class in 1985. He was awarded the Commonwealth Scholarship to study at the University of Oxford, and after he obtained his doctoral degree in 1989, he was called to the bar at Lincoln's Inn. He engaged in full-time commercial practice in the City of London at South Square Chambers, Gray's Inn, London, and became a QC, Queen's Counsel, in 2003. He subsequently became a Senior Advocate of Nigeria in 2004. He served as a consultant to the United Nations Commission on International Trade Law, that's UNCITRAL, from 1995 to 1999, and has been a visiting professor at Oxford University Faculty of Law since 2000. He's a member of the London Court of International Arbitration and also a member of the Board of Trustees of Foundation for International Arbitration Advocacy. The theme of our lecture today is the evolving role of senior advocates in the administration of justice and nation building. It therefore gives me great pleasure to invite Professor Fidelis Odita to come and do justice to that topic.
My Lord, the Chief Justice of Nigeria, my Lords, Justices of the Supreme Court of Nigeria, my Lady, Justice of Court of Appeal, distinguished senior advocates, invited guests, ladies and gentlemen, I feel greatly honored to be invited to give the maiden lecture of this very distinguished body. There can be no better time, perhaps, than now for us to look at the evolving role of senior advocates in justice administration and nation building. Our nation is challenged in very many ways. Socially, we're contending with genocide and ethnic cleansing, almost Rwanda in installments. Faced by Boko Haram insurgency in the northeast, widespread kidnapping, banditry, in fact, breakdown of law and order. Anarchy and insecurity have become the order of the day. But our challenges are not just social. We're also challenged economically. Each and every one of us is suffering the economic effects of economic management or mismanagement of our economy, deep devaluation of our currency, slow economic growth, lingering recession, widespread youth unemployment, pervasive adult underemployment, and the challenge of trying to keep body and soul together. Our politics has fared no better. We're challenged by political intolerance, political immaturity, the greed, the arrogance, the indiscipline, and the recklessness of a political class, and of course, real concerns about the 2009 general elections, which are around the corner. Our legal system is also challenged by unacceptable delays in the administration of justice at all levels of decision making, lack of capacity and infrastructure in the judiciary, a weak case management regime, chaotic, disorderly, poorly administered, and ineffective court registries, widespread misunderstanding of the role of courts in civil litigation, and the seeming inability to bring criminal transgressors to book. Against this background, the question is, what should the proper role of senior advocates of Nigeria be, both in relation to justice administration and nation building? In order to attempt to answer this question, I have broken my presentation into 4 different parts. The first part, we look at the history, the privileges, and the eligibility for the rank of senior advocates on Queen's Counsel. The second, we look at what the proper role of senior advocates should be in justice administration. And closely related to that, in the third part, I'll look very briefly at the role we should play as nation builders beyond the narrow confines of self-interest and legal practice. In the fourth part, I'll look at the challenges facing the rank and the challenges facing justice administration in Nigeria today. And then I'd like to conclude with a note on how to address female judges. The rank of Senior Advocate of Nigeria, which is conferred pursuant to Section 5(7) of the Legal Practitioners Act, I understand was first conferred on the 3rd of April, 1975 on the very distinguished late Chief F.R.A. Williams and Dr. Nebo Graham Douglas. Prior to that, distinguished Nigerian practitioners who practice here were awarded the rank of Queen's Counsel until 1963 when Nigeria became a republic, and it appears that the rank of Queen's Counsel either fell into disuse or was abolished and remained abolished until the rank was reinvented as Senior Advocate in 1975. Between 1975 and today, in fact, in the 40 years that the rank has been in existence. According to the book, 478 individuals have been made Senior Advocate of Nigeria, but of course, according to the Legal Practitioners Privileges Committee website, the number is 429. But I believe the number I see in the book. And so 478 people have been honored during that time. The rank itself, of course, is a child in many respects of the rank of Queen's Counsel, which itself is of considerable antiquity. The QC was first awarded in 1604 to the very eminent English jurist, Francis Bacon. It was conferred to recognize excellence in advocacy, not excellence as a lawyer, because one can be a lawyer as a conveyancer, and one can be a lawyer as an advisor to various organizations. But the rank was chosen to recognize excellence in advocacy. The rank is much sought after by practitioners and by clients, and has been adopted in very many countries across the world, especially those that have adopted the English common law, including Canada, Australia, Singapore, Hong Kong, India, Kenya, Mauritius, Zambia, Uganda, to name a few. The essence of the rank is the same in all these jurisdictions, but for historical reasons, the nomenclature differs. In some of the Australian states, they retain the title Queen's Counsel, so also in some of the Canadian provinces. In other countries, following the attainment of independence, the nomenclature was changed from Queen's Counsel to Senior Counsel, or in the case of some countries, State Counsel. So we have QCs, SCs, senior advocates like India and Nigeria. But the rank has one thing in common, no matter the nomenclature, to recognize and identify those who the system recognizes as excellent advocates. By convention, the rank of the Queen's Counsel has certain formal privileges. The first is the privilege to wear a silk gown. And I think it's from there that the idea of becoming a silk or being admitted to silk arose from. The Queen's Counsel, both in the past and the present in the United Kingdom, are allowed to wear the silk robe both as a working gown and as a ceremonial gown. By contrast, the junior barristers wear the stuff gown, or what they call the khaki gown. It's still a gown. Secondly, the Queen's Counsel and the senior advocates of Senior Counsel are said to be admitted to the inner bar. As far as I know, there is probably no court system that has retained the inner bar as opposed to the outer bar. The inner bar is now symbolized by the front row in most courts. So as a formal privilege, by convention, the Queen's Counsel is allowed to sit on the front row in cases where counsel is required to be robed in England. Where robing is not required, it is free sitting. You sit where you like. But of course, in practice, the QCs sit on the front row. And finally, the QCs formally were allowed to call their cases out of turn, again by convention, not by statute. But that privilege has waned and almost disappeared because of the listing system. Most matters come to court as a fixture, so some cases were listed at 10:30, some at 11:30, some at 2 p.m., some at 3 p.m. And because you have that multi-tiered listing, it is not very often that you find advocates of different seniorities in court doing different matters at the same time. And so if your matter is listed at 10:30, it's likely that you'll be the only person in court, and therefore there will be no occasion for you to mention your case out of turn. We used to have very minor seniority in the motion courts, but the motion court has become almost a relic. In the motion court, on motion days, everyone turns up, and you have a motion judge. In that sort of system, you can call your case out of turn. But the motion court has virtually disappeared. And so most motions are heard either by QC sitting as deputy judges of the High Court or by proper judges of the High Court. And so the rank exists in England now, not more in terms of privilege, because the privilege that remains is largely the silk gown and the full bottom wig on ceremonial occasions, but more as a matter of prestige and earning power. In many cases where clients are billed on the hourly rates, it is not unknown for QCs who, as junior counsel, were billed out at £400 or £500 an hour to jump to £750 an hour overnight, just by the conferment of that title. And many QCs have been known to make a fortune upon becoming Queen's Counsel. And so also a few QCs have been known to become impoverished by becoming a Queen's Counsel, because when you become a Queen's Counsel, you become the baby of the rank, and you may never make it. And there are very many examples of QCs whose practices failed to take off, and therefore who would have been better off not applying for the rank, because as junior practitioners who were led, they had very extensive practice, but as leaders, they had no one to lead, and therefore had to read newspapers or end up tidying their rooms endlessly. Of course, when you go to people's rooms and you find them checking their shelves and making sure that things are nice and proper, you know they've got no work. And unfortunately, as you know, because every barrister in the UK is self-employed, the fact that other members of your chambers are very busy means absolutely nothing to you. Everyone can be very busy, but you'll be chewing your fingernails. In Nigeria, the privileges of senior advocates derive in part from Section 5, subsection 7 of the Legal Practitioners Act, and also the senior advocates' functions and privileges rules. It's the same three privileges, but they seem to be more important here because our courts are always full. And the first is the privilege to sit on the front row and to wear your nice silk gowns, and the second is to call your case out of turn. The privilege to sit on the front row is great because often the courts are overcrowded, and it means that you always have space in court, no matter how late you turn up. Similarly, the privilege to call your case out of turn is a real privilege because often many cases are listed. The judge might have 30 cases on his or her list, so the ability to call your case can be the difference between having the matter heard, at least in part, or having to take an adjournment which may last severally up to 6 or 7 months in some cases. So the privilege is real. And also because as a society we like ceremonies, of course we do get to wear our silk gowns and full bottom wigs rather more often than we do in England. In terms of eligibility, the criteria appear to be broadly similar, whether it is Queen's Counsel, Senior Advocate of Nigeria, State Counsel, or Senior Counsel. In England, you have to be in practice for 10 years. In Nigeria, you're required to be in practice for 10 active years prior to applying for the rank. And many systems have articulated what the criteria are for the conferment of that rank. In the case of the United Kingdom, following the calls for the abolition of QC in 2003, just after I got mine, the rank was suspended for 3 years and was not conferred again until 2006 because the Lord Chancellor at the time, Lord Irving, Derry Irving, wanted to get rid of the title. The system is now run by an independent an independent body called the Queen's Council Appointments, staffed by both professional and lay people who are responsible for advertising, interviewing, and recommending the QCs to the government. Every year, they publish what they call the competency framework. The competency framework identifies the skills which the selectors are looking for. In the 2008 competency framework, 5 competency skills are identified. The first is understanding of a law, and the examples are given. The second is oral and written advocacy. The third is ability to get on to work with others, surprising as that might seem. The fourth is diversity, awareness of cultural issues. And the fifth and final is integrity. Everything comes down to integrity. And it's very important. You take integrity for granted. And we'll come back to the subject of integrity. But those are the 5 criteria which are evaluated. So when you are invited as an assessor, whether as a judge or as a Queen's Counsel or as a referee to support someone, you know that you have to evaluate them and write your reference by reference to those 5 criteria. It is not enough simply to say, Mr. Joe is an excellent advocate. That is waffle. It doesn't mean anything. You've got to nail that down by looking for examples measured across the 5 competencies which are being tested. In Nigeria, the Legal Practitioners Privileges Committee has published, and I think it's commendable, the SAN guidelines. I haven't seen anyone for 2018, perhaps because it's still at a very early age, but the 2007, 2017 SAN guidelines emphasize a number of skills. When you read the guidelines, somehow you can understand what the guidelines are trying to do. First of all, you start with the first paragraph, which tells you that the SAN is supposed to recognize very distinguished advocates. And then you get to paragraph 2, which is said to be the principles. And it's not clear what those principles are, because it says the award is based on the independent indication of excellence in legal profession. It doesn't even say legal practice, so you could be excellent as a transactional advisor. It said it is to provide a public identification of advocates whose standing and achievement would justify an expectation on the part of clients, the judiciary, and the public that they can provide outstanding services. That is good. So it identifies what we're looking for. But then it goes on to list a number of other things. For example, all applications are considered without reference to ethnic origin. It's a curious thing to put in a document like this. And that's paragraph 2B. But then paragraph 2C then says, in the award of SAN, every effort shall be made to reflect national character. So on one hand, in paragraph 2B, you say these applications are to be considered without regard to ethnic origin. And then the next paragraph, you say that every effort should be made to reflect national character. So there is a bit of confusion in the document. We need to think about the document. And then you ask yourself, what is it that we're trying to get at? I researched to see what the competency framework is or should be. But the closest that I came to is paragraph 19 of the guidelines. And I'll come back to paragraph 2 because it does contain some other gems I want to highlight. But in paragraph 19, I beg your pardon, it says a candidate must, 1, demonstrate high professional and personal integrity, B, be honest and straightforward in all his professional, personal dealings, C, be of good character and reputation, D, be candid with clients and professional colleagues, E, demonstrate high level of understanding of cultural and social diversity, which characterizes the Nigerian society, F, show observance of a code of conduct and etiquette. And these are fantastic criteria to judge potential applicants. But then he goes in paragraph 2 to say a candidate whose application contains false or misleading information will not be considered for the award for 10 years, which is great. And in paragraph 3, it says a candidate must have sound knowledge of the law. And then paragraph 4, every candidate for the rank shall provide the following information to assist. Then it lists things that you should provide, a list of 10 judges, a list of 6 legal practitioners, and so on. So it's not clear to you as an applicant what competency this 19 is looking at. But I suppose if you read 19.1, which lists what I would regard as integrity factors, and 19.3, which talks about legal knowledge, and then you have to go to 19.6, which says a candidate for the rank of senior advocate should demonstrate tangible contribution to the development of a law through case publications and scholarly presentations. And then 7, must demonstrate leadership qualities. So we've got all these things there, and I think they are fantastic. But then when you come to the scoring, how the committee actually scores, you then find that the committee does not score by reference to any of these things. Because you'd have thought that if there were 5 criteria by reference to which advocacy excellence should be judged, the marks should be allocated. So, for example, in the case of the United Kingdom, where you have knowledge of the law, advocacy, working with other people, cultural diversity, integrity, you could say you're allocating 20% to each of those. So you know what you're evaluating. But when you get to our own system, I must find it. Paragraph 16. The evaluation of a candidate's competence shall be based on the following weighted criteria. First, integrity, 20%. B, opinion of justices, judges, and the strength of references received, 20%. What does that mean? You'd have thought that the opinion of judges and references must be to judge the criteria articulated, not as a freestanding element in itself. So why would the opinion of a judge be 20%? 20% of what? So if a judge says you are great, then you get 20%. Why should you? How does that show you're a great advocate? And then it talks about quality of law office and law library, another 15%. And that's why I say that the framework, the guidelines are opaque. All the information you need are there, but the guidelines need to be streamlined, need to be articulated so that one knows what one is looking for. Of course, it is great to have a great law library. It is great to be supported by judges and by your fellow practitioners who write references, but you must know what it is that they are evaluating, and you must evaluate by reference to those criteria. So you could say, for example, in terms of eligibility, you must be a legal practitioner, you must be in practice for 10 years, you must have a great library, you must be sociable, you must not steal. You could do all that. But then when you come to allocate your marks, you might say knowledge of the law, 10%, integrity, 20%, diversity, 30%, good working relationship, 5%, integrity, and so on. So the marks must be allocated by reference to the selection criteria. You cannot allocate marks in a haphazard way. Because when I looked at the guidelines, although I can see that most of the information that we have in the QC appointments and the SAN appointments are similar, in terms of what's the focus and what you're trying to evaluate, the emphasis was a bit different. But so this is something that we can look at in the 2018 guidelines, so we can streamline the information which is required so that applicants know what exactly they are looking for. Now, having said that, and having wasted most of my time on these guidelines, can I now move on to the role of senior advocates in justice administration? Now, in the days before films and television, eminent barristers were celebrities because criminal trials and defamation trials provided great entertainment for the public. Given that there was no television of him, the only way you could be entertained is to come and listen to some very interesting cross-examination. Barristers were given to waspish oratory because they were addressing members of a jury. And you would listen to great flights of rhetoric because they were trying to entertain and to address. Today, that has changed. Advocacy has become largely a matter of fact, based on three competencies, based on three pillars, I beg your pardon: the competence, preparation, and integrity. So all forms of advocacy today are presentations, and those presentations are based on those three pillars. To my mind, the senior advocate of Nigeria today has 5 essential roles. The first, and which all the speakers have identified, is to assist the court to achieve the objectives of civil and criminal litigation. Of course, an advocate, whether senior or junior, must present the client's case in using all proper and lawful means. But he must discharge his or her first duty to the court to assist the court to resolve the dispute. An advocate, over and above the duty of candor, which is taken for granted, must not take a step knowingly which is intended to frustrate the smooth progress of litigation, whether it is criminal or civil litigation. Of course, in Nigeria, we know that this is very often abused. And as a cynic, I often say that the problem in Nigeria is not access to justice, it is exit from justice. When you get in, you can't extricate yourself. You get tied down in various ways, use and misuse of interlocutory applications. And we say justice delayed is justice denied. The second role of a senior advocate is leadership in and out of court. Senior advocate must be an exemplar of good behavior at all times, and this requires the senior advocate to be cautious to the court. Courtesy to the court is very important, and to other practitioners. A senior advocate should be the voice of reason and moderation. Should not be pompous or arrogant or see his role as a platform for rudeness or tyranny of anyone. Thirdly, as senior advocates, we must see ourselves as role models. Whether we like it or not, we have an obligation to groom the younger ones. They say everyone is a copycat, but not less the young lawyers. So many of them try to mold their practices and the way they conduct themselves in and out of court according to how they've seen the seniors behave. And so for those seniors who come to court like that, some of the juniors want to emulate that. But we must set good and high examples, because that is the only way that the prestige of a rank can be maintained. And mentorship is not just by leading by examples. We must go out of our way actively to develop the young members of our profession. The fourth role that I see for senior advocates is to ensure the prestige and survival of a rank. You know, everyone talks about the ubiquity of English law. But we all know that most of English law is judge-made. It's between the advocates and the judges. Today, over 75% of commercial disputes that are settled in England have nothing to do with England. There is no English party involved. There's no English plaintiff, no English defendant. The only thing that is English is the choice of English law, the choice of English jurisdiction, or the choice of arbitration in London. But they have attained that height in part because of the robustness of the system, but also because of the eminence and the examples that the leading advocates have set. And that is why when the rank was sought to be abolished in England in 2004, the polling that was done showed that the QC system was part of the attractiveness of English law, and that many people chose English law because of the ability to obtain QC's opinion. And for those who practice insurance and reinsurance, you see that very often insurance clauses provide for a QC opinion being required in relation to certain matters. And that is because those QCs have carried themselves in a way which has evoked public confidence, not just in English law, but in the office of the senior, I beg your pardon, of the Queen's Counsel, the senior advocate. And finally, senior counsel is normally, in most systems, a pool from which you recruit your judges. In England, 99% of all judges of superior courts are appointed from the rank of Queen's Counsel. And in my own chambers, in the last 3 years, 2 of my colleagues have gone to the bench, one in the commercial court, another one in the Chancery Division. And when you have judges who have practiced at that level, it is obvious that the quality of the judgments will be better. Because first it will take you less time. The judge you are making submissions to, it says you're trying to push through an open door. He's very familiar with what you're talking. She's very familiar with what you're talking about. But in Nigeria, the senior advocates have not been able to perform this role. As far as I'm aware, senior advocates are not appointed to any, they're not appointed as judges, whether to the High Court or to the Court of Appeal or indeed any superior court. So, how have the senior advocates fared? In my view, without any doubt, the rank of senior advocate has very largely identified and recognized the very, very best advocates practicing law in Nigeria today. Whatever anyone might say about the SANs, and of course, the rank is very polarizing. Many things have been said about the rank. There is no doubt that the most eminent advocates are to be found in this room. And to that extent, the criteria for the selection and recognition has largely worked. It has identified the very best advocates. But like any system, you cannot always get it right. Even as a law tutor at Oxford, we used to find kids that you interview every December for 20 minutes, and they deceive you that they're very clever, with their waspish oratory. And you say, well, this is going to be a great lawyer. It'll be fun to teach. And then they turn up. They are hopeless. You're trying to send them down. It doesn't mean that you didn't select them or that they didn't meet your selection criteria. It simply means that you have made a mistake. So the fact that the system makes mistakes from time to time and admits a few people who are said not to be worthy is not a reason for condemning the rank as a whole. The rank is a very valuable rank. But having said all that, in my view, there are 2 sets of criticisms that have been advanced against us. One set relates to the appointment of SANs, and the second relates to the conduct of the senior advocates. In relation to the appointment, it is said that the method of selection is opaque and contradictory. And I think I referred to some of the provisions in the guidelines which might suggest that that is the case. There is also complaint that it is based on quota. Why should it be capped? Everyone who merits it should be given. A third, it has been criticized on the basis of federal character. And I find that myself very surprising. I know in Nigeria, we're all about federal character, but in my view, the federal character has impoverished the nation rather than enhanced it. I don't even think that it has achieved the unity which was intended. But whatever the merits of the federal character may be, and when you look at section 14, subsection 3, and section 14, subsection 4 of the Constitution, which enshrine federal character as among the fundamental objectives, they talk about the composition of government at all three levels and the population of government agencies. Well, the SAN rank is not a government appointment. It's not a government agency. So why are we trying to mimic what the people are doing? We say that the federal character has been used to disdain merit and to promote mediocrity. And among a very elite audience like this, we're still doing the same thing. Who are we trying to impress? Come on. It is also said that the competency framework in Nigeria involves a lot of ticking the box. So you are asked to put down 20 cases which are said to be significant or complex, 20 at first instance, 6 in the Court of Appeal, and 5 or 4 now in the Supreme Court. And that type of numeration of cases favors ticking the box rather than qualitative assessment. Who actually reads all these submissions to see the quality of the advocacy? He said the rank has also been politicized because the children of judges and leading sons tend to be more successful than the others. So there you are. They might say it's bad belly. So you should disown your parents if they are judges or successful SANs, because it might be thought that they have assisted you. They are there to assist you, provided they assist you properly. Now, as regards the conduct of SANs, there are 3 real problems. You can talk about many examples, but there are 3 major criticisms. The first is that the SAN has become a bullying tool against the bench, other lawyers, and the public. And it's become an irresponsible professional self-adulation, self-congratulation. And so it entitles you to throw your weight and to strut around the courtroom like a peacock. It is also said that the privileges of the SAN are discriminatory because it gives the wrong impression to the lay client who is in court that the reverence shown to the senior advocate is likely to influence the judge in the disposition of the case. SANs are said to aid and abet corruption, in part by deliberately frustrating the fight against corruption, and in part by themselves being the ones committing the corruption. So basically, obstructing the progress of the law, indiscipline, and lack of integrity. I think as regards obstructing the progress of cases, I don't know of anyone in this room who has not filed an application which has tended to slow down, if not completely obstruct, to slow down the pace of a case. But that's the system that we have. We have to change that system, where the pace of litigation is dictated largely by the practitioners who file applications, whether spurious or otherwise, calculated deliberately to impede the progress of cases. But let me talk about integrity, because we rest on our integrity. The survival of this rank and the respect which it attracts and the respect which we demand and expect others to accord to the rank depends on us being seen to be honest professionals and to practice according to the letter and spirit of the rules. The rank faces existential threats from a lack of integrity among a few practitioners. Among the rank of senior advocates, there are those who have been said to doctor court records. There are those who have been said to manufacture evidence. There are those who are said to be specialists in fake service, where they pretend that they have served the other party and they get acknowledgement and file, whereas no one has actually been served. And so many other forms of misconduct. And you ask yourself, how can people who hold themselves as a paragon of the profession, the people who are the pinnacle of the profession, descend to such levels of fraud? And I'm not talking about bribing judges or anyone. I'm talking about their own fraud in trying to win at all costs. What the rules require us to do as advocates and leading advocates is to present the cases of our clients fearlessly and courageously by all proper and lawful means. The rules do not require us to win at all costs. And we cannot tout ourselves to our clients by telling them we win all our cases. If we win all our cases, then there's something wrong about our practice. How can it be that on every occasion, the facts are in your favor, the law is in your favor, the judge is in your favor? If that happens to you sometimes, that is correct. But if it happens to you all the time, then something is wrong with you. So it is not the example that we want to show to others, and we must do something to correct it. Let me run quickly through what I see also as impediments which we as senior practitioners face in trying to help in the administration of justice in Nigerian courts. I've already dealt with the problem of delay. We all know, the judges, the lawyers, all of us know that delay is a real problem. But what I find more surprising is that a source of the problem that we face as practitioners is the definition and allocation of jurisdiction between the federal and the state courts. I find almost 40% of appeals are based on you are in the wrong court. How can we? The Federal Revenue Court was created in 1973, some 45 years ago. And today, 45 years later, we are still arguing about the allocation and definition of jurisdiction between the federal and the state courts. It is a great indictment on all of us who have allowed this system to fester. And it is a waste of public money. We also face the problem of the misuse of jurisdictional objections, and these are our own judge-made problems. The misuse of jurisdictional objections and the misuse of interlocutory appeals. Of course, everyone knows that jurisdiction is the lifeblood of a case. You cannot place something on nothing, Madukolo and Nkemdilim, But all those things are just catchphrases. They're catchphrases. We have to interrogate them. What do they actually mean? If a thief comes to my house and steals my 5,000 naira, of course he acquires no title, and therefore you cannot place something on nothing. But yet the thief can give title to someone. So if the thief takes my 5,000 that he stole from me, having acquired no title, and he comes to Intercontinental Hotel, I dare say he could probably buy lunch with it, and title will pass. So it is not always correct to say that you cannot place something on nothing. You can place something on nothing sometimes. But we need to know circumstances where you can and circumstances where you can't. But just to invoke the catchphrase obscures analysis and just leads to answers which challenge reason. But the judges are responsible for this. Even if we accept that jurisdiction is a lifeblood. In England, many jurisdictional issues are resolved as part of a trial. So you think that this case is a statute barred, and therefore the court does not have jurisdiction. Great. Plead it. So it becomes part of your defense. But you cannot stop an entire trial just because you say it's statute barred. If the judge agrees to isolate that as a preliminary issue, that's a different thing. But if he doesn't agree, you have to take your case, do your trial, call your evidence. If you win, fine. If you don't win, take up the limitation point as and the ground of appeal. But in Nigeria, because jurisdiction is the lifeblood of the case and must be resolved first, you can take it from the High Court to the Supreme Court in 12 years and then nothing happens. You don't need rocket science to see that that is a system which is designed to fail. So I come to Nigeria, I find that if I raise a jurisdictional question, I can delay the trial for 12 years. In life and in advocacy, 12 years is a lifetime. If I can prevent my client from going to jail, or I can prevent my client from paying for 12 years, hey, I would try to do so. My client will probably want to do so. Because at the end of 12 years, the Supreme Court awards cost of 200,000 naira or 500,000 naira. So what incentive do I have not to take that jurisdiction? I must take it because that's the system that I see and my client wants it. So you cannot blame the senior lawyers for doing it. You have to blame the judges who have allowed that because these are judge-made rules. These are not matters of statutory interpretation. There is no reason on earth why a jurisdictional objection cannot be tried with the substance. Our own jurisprudence is based on 19th century jurisprudence, which is completely outmoded. And until we tackle that, we're not going to make any progress. We can reform as much as we like, but we'll have to deal with that. That problem is closely allied to the interlocutory appeals, which are the bane of civil and criminal litigation. Before you say Jack Robinson, they are in the Court of Appeal. And then they are applying for a stay. So your witnesses have been all lined up like a ducks in a row. Some have come from abroad, they've come from everywhere. On the day of a trial, someone tells you, this appeal has been entered. We have an application for stay. Then the entire preparation becomes wasted. The people who came from abroad as witnesses, no one is going to refund them their money. Even if you win your case after the interlocutory appeal has finished 10 years' time, they will give you 500,000 naira. We go to the Supreme Court in Abuja, where you win and they give you cost of 200,000 naira. The cost of a flight alone is more than 200,000 naira. And so you are asking yourself, please, my lords, where do you live? How do you think I magicked myself to your court? Huh? I came, I flew by Astra traveling, I did not incur any costs, and you're awarding my client 200,000 naira for a successful appeal that has taken 10 years. Come on, that is not credible. You cannot do that. And the reason I mentioned the cost is that you cannot have an effective civil or criminal justice system where you do not impose proper costs. Not just costs to indemnify the party, but also wasted costs. I see some examples that the Supreme Court awarded 5 million naira against Mr. Nwofo some time ago as wasted costs. That is to be welcome. But the jurisdictional reforms and the costs go hand in glove. We must do the same. The cost of hiring anyone in this room, if the person is very cheap to do a high court matter, will be at least 5 million. Another 5 million in the Court of Appeal, and maybe 10 million in the Supreme Court. And then you win your case, plus other costs. The court awards you, say, costs of 200,000 naira hereby ordered. And you ask yourself, did I hear right? What is that supposed to be? And the courts do so because they think they must summarily assess every cost. No. The rules provide for you to file your costs application. There is no reason why you should not file your cost application. Show how much you paid. Show how much you paid the hotel. How much Arik took. How much this person took. How much the witnesses paid to come, whether they are coming from London or they are coming from Calabar. And then you total all of them, and the judge makes an order. So a trial that took 3 years, and either party paid over 100 million. So if you look at election petitions as an example, where they are paying counsel $2 million or $3 million, and then you win, someone says they should pay you cost of 100,000 naira. How? You must tell litigants that the court is a very scarce resource. Unless you tell them that and give them an incentive to litigate responsibly, they are going to continue to abuse the litigation. Just 2 more points. I'd like to talk very briefly about the court registry. As I said earlier, I have found our court registries to be a disgrace. Our court registries are chaotic, disorganized, dirty, very poorly administered. As a result of the failure of the registry, when you get to court, you find that the judge is performing a registry function. So the judge is asking, okay, you said you filed your application and is scrambling through disorganized paper in the file. When did you say you filed this? Registrar, look for it. And then you're just looking very amused. This is supposed to be a serious business. And the judge is saying, registrar, can you find it? And then those ones are scrambling through and you're saying, what is this level of chaos? Something as simple as asking to ensure that these things are in apple pie order. How can we not get this very basic thing right? And you go to the Supreme Court, and I have said this to them on a number of occasions. You say, my lords, we came to move this application. Say, when did you file that application? We don't have it in this our file. Registrar, where is this? And you say, this is the Supreme Court. Where you enter, it should be a solemn occasion. When you enter the Supreme Court of the United States or the Supreme Court of the United Kingdom, you feel you are in a very august and special place. All this nonsense about paper and no paper have been sorted months ago. You cannot come into that court and be looking for any paper. For what? How? Your case is listed for you and you're allocated 2 or 3 hours to argue your appeal, and someone is looking for paper. It's impossible. Because weeks or months before then, all the papers have been sorted. They are all there waiting. They have been read. The people are waiting to interrogate you. They have views on almost everything you've written. And you are just yourself. You'll be the one under pressure, trying to answer questions. But not so for us. And so you ask yourself, I received a notice of hearing in the Supreme Court of Nigeria by text on a Saturday, telling me that my appeal, which was pending for 8 years, was due to be heard on a Monday. And I was in London. So I had to bring myself back, because it's not their fault that I put myself in London. I had to look for a quick flight and came back first to Lagos to carry my paper. Then I read all night. And I turned up on Monday. And then there was a letter from Alhaji Abdullahi saying he too got the text, but he's not able to turn up, and I don't blame him. Why would you receive a text on a Saturday? So he didn't come, and the matter was adjourned. So my flight money, the risk I took, I could have died in the plane. And this is an appeal that has been pending for 8 years. The idea that they gave a text message as notice of hearing for an appeal that has been pending for 8 years. I say to us, we must do better than that. We cannot keep blaming everybody. We must do better than that. So until we sort these problems, the system will continue to creak. It cannot. The judges are hardworking, but if you don't have a registry that works, your engine room is, the engine is blown. You cannot do anything. I have said many times to the Supreme Court, these things you are doing, you are performing registry function. I am not responsible. They're asking me, when did you file your paper? I said, I'm not a registrar of this court. I'm a senior advocate coming to make submissions on behalf of my client. I'm not an assistant registrar. Ask your registry how. Of course, they don't like that because it's rude, and we're very deferential people and so on. But you have to tell them the truth sometimes. So can I say something very briefly on case management? On the case management, I think some of the problems we have in the administration of justice in Nigeria can be solved through stronger case management. And I think that, as we notice quite often, the appellate courts must support the lower courts. If I decide, as a high court judge, that I want to give you 2 weeks to file your papers, the Court of Appeal should support me in that decision. because the discretion is mine. It cannot be said to be rational. I must have taken some considerations into account in fixing the 2 weeks. Maybe if the Court of Appeal judge were the one exercising the discretion afresh, he or she may give 4 weeks or 1 week, as the case may be, but that's not the point. But often you find that the appellate courts interfere with the case management decisions. And when you do that, all you are inviting is more and more appeals. Because if the High Court gives 2 weeks and then they come on appeal and you dismiss the appeal and impose 2 million naira cost, no one will come again. They will now go and rearrange their affairs and do it in 2 weeks. But if you allow the appeal, then, of course, you're encouraging them to come. And then you complain in the Court of Appeal that you are all very busy. And in the Supreme Court, you will continue to be very busy unless you allow them to do what the Constitution has given them power to do. But also, we must encourage our judges, some of them, at first instance, maybe because of the size of the dockets, routine applications that should be subject of a bench ruling. For example, I want to tender a document, and someone objects to it. And you'd have thought that because we're told that you should be master of the law, master of procedure, and master of evidence, that the judge should be able to tell you whether he or she believes this document is admissible or not. In many cases, you get an adjournment to go and rule on whether this piece of evidence is admissible, and that now keeps the trial away for sometimes 2-3 months. And then when you turn up on the day of the ruling, you'll be waiting in open court because they're writing the ruling that morning. So what's the point of waiting for the 6 or 8 weeks? And you say, look, as a people, we are all responsible for this. And I keep saying we should challenge ourselves. We can do better. The judges that are performing excellently in our system are here. We should support them. But we must not allow ourselves just to give up and say, oh, it's the system. And allied to that, a problem we find a lot at first instance in Nigeria are cases that are fixed and you turn up and the judge is not there. It is almost counterintuitive. When you go to the appellate courts in Nigeria, the Supreme Court, they all sit on time. At 9, everybody turns up. But then you go to High Court, 10 o'clock, 10:30, some of them have not come. Sometimes they'll say, oh, he went for a funeral. He went to the market. He went to drop a child. In one case, the judge said he stopped at an ATM to withdraw money. And then he attended seminar. And you're just saying to yourself, for Christ's sake, how can we reduce our system to that level? What do you think people are going to? So we keep saying foreigners are not coming. All the arbitrations are going to other countries. Nobody wants to litigate here. If you were not in Nigeria, would you want to litigate here? I keep saying Nigeria is an acquired taste because it's our country. But if you have a choice, why would you choose this system? That is a question we have to ask ourselves. So in order to make our system attractive, we all have a responsibility as practitioners, as judges, to make sure that we do our best to promote the system. And in saying that, I must acknowledge that there are some judges doing fantastic things. And if I may say so respectfully, my Lady Justice Ogumiju, I have singled her out because she's here, but also because she's done something which is worthy of commendation. For a number of years, Nigerian law and practice was blighted by a case relating to enforcement of judgment and garnishes, where the Court of Appeal, in its infinite wisdom, said that a judgment debtor is not a party to garnishee proceedings. Therefore, you can seize all their money, without hearing anything from them. As a lawyer, that seems very funny as a proposition. But you then find that there are many cases in the Court of Appeal endorsing this principle, many cases, that the judgment debtor is not. And of course, that encouraged many cowboy practitioners, including some of us as senior advocates in Port Harcourt and many parts, who seize people's monies. And people build practices on that. But in a series of decisions that she gave, she corrected that fundamental and basic error. In the last of the cases, sitting in the Benin division, she invited 4 senior advocates as amicus to write submissions for the court to consider this issue. She did that based on her own initiative. No one asked her to do it. And that is taking responsibility. Not only had she done it in 3 previous cases, on that occasion, she widened the debate by saying, okay, I need submissions from 4 senior advocates, 4 different senior advocates acting as friends of the court in order to consider the issue properly and to bury the ghosts of the previous case law, finally. And I think that our judges, many of you can do the same thing. Many of you can do better. And we implore you to try your best. We know it is a very difficult place, very challenging terrain to work in. No one pretends that things are easy, but there are many things that you can do to help us. For example, the time that you fix for the judges' conference. After going away on vacation for 2 months, you then come back, and the first thing you do is to go on judges' conference. And all the cases listed for the 1 or 2 weeks are adjourned repeatedly. And so people lose 6 months. But we don't see this in England. It's impossible. If the judges are going to have a conference, they must have it during their vacation. How many days does it take? How can you have 2 months and then you come back, cases that have been fixed, you say you are going on a conference? What does that mean? What does it mean? Someone should help me. Tell them how. I'm able to continue my practice in England because the fixtures work. So when the case is fixed and I fly back to, the case must go ahead. The case must go ahead. I have had no single instance where a case did not go ahead. Where there is difficulty, they will tell you 2 or 3 weeks before the time. And so you will know. It will be released, and therefore, for counsel who is based on brief fee, your client can avoid incurring it. Because if I take a brief fee, and then on the eve of the commencement, the judge adjourns, I've earned my brief fee. I can't return the money to the client. If the court should fix the case subsequently, the client must pay me another brief fee. Because I've already prepared for that case. The fact that the court did not sit is not my problem. I don't run the courts. So he will pay me. But in Nigeria, we impose all the problems on the counsel. The judge doesn't sit, the client will not pay. The judge does this, the client will not pay. But it doesn't work like that. And we can actually do better. I agree that in some cases the notice is too short. We cannot know. But you should be able to have some flexibility. And maybe you need some constitutional amendment. Maybe you need to appoint more judges. Maybe you need to take a case file. So if my case is fixed in the High Court to start on Monday next week, and then on Friday they find that the judge who is going to hear the case is in difficulty, they will take my case to another judge. But the case will go on that Monday. But here, once they assign the case to a judge, it then becomes the owner of the case forever. And that is part of the problem. Whereas anyone can read a file and say, okay, so yeah, your pleadings are here, yes, what's the application? And then decide it and return the file to the registry. But here, because we think that once a case is allocated to a judge, the judge must keep that file forever, it means that if the judge is not available, no one else can. No. All of them are exercising the same powers. So the fact that Justice Ogumiju is not available does not mean that my Lord Justice Eko is not available. So you can do that. take cases and allocate. The only time that we see that here is in the Court of Appeal, in Lagos at least, between the two courts, and then sometimes with the vacation judges. But the ability to take a case file, this case is urgent, give it to this judge. Of course, in Nigeria, they will say, that judge, they've given him money, and that's why he's taking it. But we have really to rise above that. We all have a responsibility to make our system work. And when I look at where our system is now, and where the system was in 1986, before I left Nigeria, I see that we have not made much progress, and it is very sad. And I think for many people who are objective and passionate about the system, in many respects, we have retrogressed. So rather than moving forward as most societies move forward, we are struggling even to stand still. And instead of standing still, we're actually moving backwards. And I think it is our responsibility as senior lawyers, as judges, to make this system work, because no one else is going to do it for us. We can introduce technology as much as we like, but as my Lord, the Chief Justice of Nigeria mentioned, we also have a problem of attitude, diligence. But we must bring back proper costs. Unless you have proper costs, you cannot make progress. Finally, I'm sorry, I know I have taken too much time. I want to address how to address female judges, because I see this all the time. And I have actually been a victim of misaddress, and you don't want to start off by misaddressing a judge. I went to court once, and I said, my lady, my name, he said, stop. I'm not your lady. I'm your lord. In order to make progress, I had to readdress her as my lord. Although I was convinced that she was wrong. And that is why I would like to conclude my talk with a footnote on the mode of addressing female judges. All over the country and at all levels of decision-making, I hear male and female judges addressed uniformly as my lord. Whilst this is understandable in the case of a male judge, it is less obvious in the case of a female judge. I am told that the explanation for this is that at the bar, there are no females. And because there are no females, the fact that people wear earrings and have braids means that they are men, just dressed and disguised in different ways. But the idea that there are no females at the bar is based on 19th century jurisprudence. It is not correct. So that premise, and I hear it every time, there's no female. If you address a woman and say, add a squire for me, that's fine. But the idea that there are no females at the bar is an outmoded idea which never applied in England. The first female judges who were appointed in the middle of the 20th century in England, they were all addressed as my lady. No one addressed them as Lord, notwithstanding that England has a feudal system. And so, in England, a high court judge who is a lady will be styled as Mrs. Justice Rose. Whether you are married or unmarried, you're always Mrs. Justice someone. You're never Miss Justice. But from 2014, we now have Ms. MS, because some of them are protesting that they are not married and they don't want to be addressed as Mrs. And of course, for many of those judges, barristers especially, they are appointed under their maiden name. And that's because many women come to the bar when they are married, and so they build their reputation around their maiden name, and they refuse to change their professional name. So at home, she may be a Mrs. Miller, but at the bar, she's Mrs. Smith. She's Miss Smith. So when she's appointed, she becomes Mrs. Justice Smith, not Mrs. Justice Miller. It's always Mrs. her name that she uses to practice. And then in court, you address as my lady. If it's a mixed court, like a court of appeal where you have two females and a male judge, you say, my lords and my ladies, or simply the court, if you don't want to get into gender issues. And then, of course, in the Supreme Court, you address them as my lady. And it is important to emphasize that because at the moment, the UK Supreme Court has got two female judges, Lady Hale and Lady Black. And Lady Hale, who used to be Brenda Hoggett, for those who studied family law and bought Brenda Hoggett's book. She used to be Brenda Hoggett, and then Brenda Hale rose and became High Court judge, Court of Appeal, first female Supreme Court judge, and now the first female president of the UK Supreme Court. And if you look at the law reports, you see there Lady Hale. And last year, Lady Black was also appointed. So at that level, Lord and Lady, in the Court of Appeal, Right Honorable Lord this, Right Honorable Lady that, and then in the High Court is Mrs. Justice, whatever. But in court address, it is always my lady. The female judges are not lords, and they cannot be lords. So I do not know where we got this from. Certainly, we did not borrow it from England, because in England, the female judges were never addressed as my lord. They were always addressed as as my lady. And if you are in doubt, you can look at Debrit's, or even look at Wikipedia. It will give you, it's all there over the internet. And so, ladies and gentlemen, it's given me tremendous pleasure, and I consider it as a great privilege to be able to address this very august gathering. Thank you.
The man has done justice to the theme. Please. May I have another round of applause for Professor Odita? The evolving role of senior advocates in the administration of justice and nation building. He started by giving us the guidelines on appointment of senior advocates, conduct, integrity, the role of the courts, how some senior advocates manipulate the system, how they should not manipulate the system, reforms that should be introduced in the administration of justice to enhance justice delivery. And finally, a very, very important topic. I happen to also be a victim of having referred to a judge as my lady, and I lost the matter in the Court of Appeal on account of that. The matter is presently in the Supreme Court. It's been there for 8 years. And I think something like that happened to Mr. Louis Banifo, who is also here. Unknown to most people, the Lagos State has had a practice direction published since the time of J.I.C. Taylor, when he was Chief Judge of the state in 1967, and it's been updated till date by all the Chief Judges of Lagos State. And the proper mode of addressing female judges is therein clearly stated. But I will not preempt the appeal I have in the Supreme Court at this stage. Now, we're going to call on our discussants, beginning with Honorable Mr. Justice Emmanuel Ayola, former Justice of the Supreme Court, to tell us in just 10 minutes what his reaction is to this theme. A round of applause for him, please.
I decide to come to the podium because if I were to talk for 10 minutes, I will sleep off. But I'm not going to talk for 10 minutes. I'm going to talk for more than 10 minutes. The simple reason is that you don't bring an old man from Ibadan to come to Lagos to talk for 10 minutes. It's been a wonderful event. When I start the 10 minutes, I'll let you know. It's been a wonderful event, particularly listening to my very good friend. He must be my good friend because he studied at Oxford, so he must be a good friend. Fidelis Odita, a man of great learning, of tremendous courage, and a man who says it as it is. It is a pleasure to listen to him. I have listened to him in court and out of court, and it's wonderful to have him amongst us in Nigeria. By the choice of dignitaries that are here, it is sure that BOSAN has indicated that this maiden lecture is truly a landmark event. The topic I was told we were going to deal with is the evolving role of senior advocates in the administration of justice and nation building, and that's a good theme indeed. It is really a deep privilege and honor, I think, and I know, to have the Chief Justice of Nigeria in our midst. I'm sure, given the opportunity, the Chief Justice, our Chief Justice, would have had or be given a privilege of response to some of the things that our principal guest lecturer has said. But then it reminds me, strangely enough, that Mr. Odita, or shall I say Chief Fidelis Odita, maybe that sounds better, have been talking on the same plane. We have been talking on the same plane because somehow he was looking at probably the horrendous bad part by showing gentlemen, ladies and gentlemen here, what is wrong with us. And everything he said was meaningful and good. But coincidentally, I was thinking of the other side. I was thinking of the other side because I know that Professor Odita sees both ways. He's an Englishman resident in Nigeria and a Nigerian resident in Nigeria. Coincidentally, when I was thinking of what to say, it suddenly occurred to me that let me visit England, and in visiting England, let me listen to one of the lords in England named Lord Wolfe. So I picked a paper and tried to find out what happened to Lord Wolfe. And I came across this. In 1994, Lord Wolfe was asked by the Lord Chancellor to review the civil justice with a view to its reform. The result was the production of a report by Lord Woolf in which he laid out the ideas for the fundamental reform of the system. He identified the problems, but let me backtrack a little again, because we have to recall that for many years, the civil justice system in England, not unlike that we are experiencing in Nigeria today, was acknowledged to be unsatisfactory. It was stated to be slow, expensive, and confusing for litigants, with complex rules which made the outcome of cases very uncertain. That was what instigated England to look for Woolf and rebuild that system. Lord Woolf identified the problems with the system as being, and I'll quote, too expensive in that the costs often exceed the value of the claim, too slow in bringing to a conclusion, and too unequal. There is a lack of equality between the powerful, wealthy litigant and the under-resourced litigant. It is too uncertain. The difficulty for forecasting what litigation will cost and how long it will last induces the fear of the unknown, and it is incomprehensible to many litigants. Above all, it is too fragmented in the way it is organized, since there is no one with clear overall responsibility for the administration of civil justice, and too adversarial as cases are run by the parties, not by the courts, and the rules of court all too often are ignored by the parties and not enforced by the courts. Let me, for a brief moment, also recall that Lord Woolf's recommendations for dealing with the problems that he had identified were comprehensive, amounting to a new landscape for civil justice. They included litigation to be avoided wherever possible, with encouragement to use alternative forms of dispute resolution, and litigation to be seen as a last resort, litigation to be adversarial and more cooperative, with an expectation of openness and cooperation between the parties from the start of litigation. Litigation to be less complex, with a single set of procedural rules for the county courts and high courts. The time scale of litigation to be shorter and more certain, with all cases progressing to trial according to a timetable set and monitored by the court, no longer left to the parties themselves. The cost of litigation to be more affordable and predictable, with, for example, fixed costs for cases on the new fast track. The structure of the courts and deployment of judges to be designed to meet the needs of litigants. These were the bulk of Lord Wolf's recommendations. In Nigeria, we have taken note. For quite a while, we have taken note of these recommendations, even in Nigeria. And it is clear to many of us that, encouraged by the efforts made in England, in Nigeria, civil procedural rules that govern several aspects of civil litigation have been revised and brought in line with a substantial part of our civil procedure. Rules of several of the federal and state high courts in Nigeria have been revised. Soon, there was an awareness and a consciousness of the need in several federal and state courts in Nigeria that the essence of establishing fresh rules is to encourage speed in adjudication. It was realized that it is needful to embrace case management in order to streamline allocation of cases and management of the speed by which cases pass through legal system. Several of our courts begin to realize and embrace the need for the judiciary to manage cases as well as costs, as to ensure the cooperation of lawyers and litigants in the expeditious disposition of cases. I think we soon realized that for the system to run smoothly and speedily, case management and court management have to run hand in hand for smooth and speedy disposition of cases. We have taken all this into consideration within the Nigerian legal system. We have fashioned mechanisms for performance evaluation. We have, over the years, though recent years, make it mandatory that judges must encourage themselves to increase the pace, to imbibe the spirit of self-evaluation. So many things are happening. They used to say that Rome was not built in a day. Nigeria too will not be built in a day. And what we know in the system is that things are certainly getting better. They may not be the best, but they are certainly getting better. And this is why, in addition to what has been said in England, we in Nigeria took the courage to fashion a national judicial policy. A national judicial policy that is holistic, that embraces almost everything that we need to develop to make our system as good as any system in the world. It is true that maybe there are still hiccups here and there, but we must congratulate ourselves that we do know that the future is going to be good. And that is why we fashioned the national judicial policy. The need to put in place a judicial policy has been borne out by the realization that the most efficient and realistic way to deal with the identified issues and problems in our judicial system is by way of a policy that will guide and provide principles and guidelines for tackling and dealing with such issues and providing actions for objective and durable solutions to the problems. We believe that in the final analysis, it is imperative that we have to promote and ensure the highest possible standard of qualitative justice delivery. Some of the policies mentioned in the national judicial policy are the judicial appointments policy, judicial discipline policy, judicial education and training policy, judicial performance policy, case flow management policy, and transparency and anti-corruption policy, which are highlighted in this paper, which I will not read. But I'll point out some of them. In regard to judicial appointments policy, it is a basic fundamental aspect of the judicial policy that judicial appointments process must be transparent and merit-based and skill-based. Because we believe in the preparation of the judicial policy which has been adopted by the National Judicial Council, a transparent and carefully designed appointment process is indispensable in an independent, efficient, and independent judiciary. Also, when we get to the judicial discipline policy, the national judicial policy ascribes much premium to judicial accountability and ethical conduct in judicial office. When we move on to judicial education and training policy, the main objective of the judicial education and training policy is capacity building and improvement of judicial officers for better performance of administration of justice. Then let me move quickly also to touch base with the judicial performance policy. The judicial performance policy deals with performance evaluation of judges. The judicial performance policy gives prominence to strategies to strengthen judicial performance through constant monitoring and evaluation, and through continuous monitoring and assessment of the adequacy of the facilities available to judges for efficient performance. To this end, the Judicial Performance Evaluation Committee has decided through the quality evaluation mechanisms already put in place to introduce new measures to ensure improved performance of judicial officers.